Senator Mitchell here in a timely fashion, and I will officially call this committee to order. We will wait till we have the necessary members to establish a quorum, but we will start as a subcommittee. We do have two items on the consent calendar, items 4, SB 1284 by Senator Hernandez, and item 6, SB 1452 by Senator Wajkowski. If you're here on either of those measures, you really don't need to be because they're on the consent calendar, and we will take that up when we get a quorum as well. So let's start with SB 1001. Senator Mitchell, we will start as a subcommittee. Good afternoon, Senator. Good afternoon. Thank you very much. And the rules of this committee are two witnesses in support, 2 minutes each, and then those who wish to identify themselves, name, identification, and their position on the bill. And then we will have 2 witnesses if there are 2 in opposition, 2 minutes each, although I note with the case, in the case of this measure, there was no timely opposition filed, so I will assume, unless we hear otherwise, that there is no such opposition. Senator Mitchell, please proceed.
Thank you. My office has not been notified of any either, Madam Chair. Thank you very much, committee. I'm here to present SB 1001, which amends the Labor Code to explicitly state that it's an unlawful employment practice to request more or different documents than required by federal law as a prerequisite for employment. In November of 2014, the President of the United States announced an expansion of what we all know as DACA, the existing Deferred Action for Childhood Arrivals, by removing the age cap, as well as creating a new program called DAPA, the Deferred Action for Parents of Americans. Under this program, individuals who came to the U.S. as children and meet DACA eligibility guidelines may qualify for deferred action and may also obtain work authorization. Although this program provides deportation relief and the legal right to work for thousands of families in California, some employers may use this newfound status to discourage or create challenges for potential job applicants. Case in point, one example where we found that abuse occurs, and that's when a prospective employer asks for an employment authorization document, although the worker has already shown state identification card and an unrestricted Social Security card, which satisfies the requirements of the I-9 form. Document abuse can even happen to current employees who've already established work authorization. While existing state law prohibits document abuse if it's retaliatory in nature, there is no protection against document abuse at the initial point of an employment application. Currently, federal law provides protection against document abuse, but these protections must be enforced through an overly cumbersome process, which makes it extremely difficult for potential workers to avail themselves of this remedy. This bill codifies federal law and states that it's an unlawful employment practice to deny documents that appear to be genuine or attempt to re-verify or re-investigate an employee's authorization to work. SB 1001 will also provide the Department of Labor Standards Enforcement the authority to investigate and enforce the prohibition against unfair immigration-related employment practices. We must ensure that Californians who have the legal authorization to work are not subjected to additional obstacles to employment once they provide acceptable documents that establish work authorization. We must not discourage families who have fought to be in proper legal status to live in the shadows because of these additional obstacles. Amendments to the bill add the protections of this bill in the Labor Code, helping to ensure consistency between federal and state definitions and requirements for employment. As a result, Madam Chair, we've been double referred to Labor Committee, and we will go there with great zeal and gusto. I have witnesses here to support SB 1001, Jeanette Zanapatin with MALDEF, and Gina De Silva, who's a policy advocate with the California Immigrant Policy Center.
Thank you very much. Good afternoon. 2 minutes each, if you would.
Good afternoon, Chair and committee members. My name is Jeanette Sanipatin. I am the legislative attorney for MALDEF, the Mexican American Legal Defense and Educational Fund. I am here to testify in strong support and as a proud co-sponsor of Senate Bill 1001 by Senator Mitchell. This bill is a critical bill for California, as Senator Mitchell made in her statement or remarked in her statement. California's economy really thrives on its immigrant workforce, and this bill would really ensure that newly work-authorized immigrants are able to enter into the workforce without facing any obstacles and without facing this type of employment discrimination. Under federal law, this practice is prohibited. It's a discriminatory practice known as document abuse, and I asked the sergeant to give you a copy of the I-9 form. Under the 1986 Immigration and Relief and Control Act, all employers are required to go over this form with prospective employees, and it clearly lists which documents they are supposed to accept in order to ensure that that person is work authorized. And what we've seen in the last couple of years, especially with the newly created forms of administrative relief that the president created, is that some employers are asking non-citizen workers for additional or different documents, which are clearly prohibited under federal law. But the unfortunate matter is that most workers are not aware that this right even exists, and much less are able to access the remedy. As Senator Mitchell stated, the remedy at the federal level is very cumbersome and very inaccessible for most low-wage workers. Workers under current federal law have to go through the Office of Special Counsel, and then it's followed by a review by an administrative law judge, and then the next level of review is a court of appeals. Because the process is so cumbersome, we feel that a state remedy is really needed so that we can ensure that this workforce is ready and able to enter into our labor market. We also think that it's important, given that there are new categories of immigrants entering that are being work authorized. We might have a potential 1 million new immigrants who are work authorized this summer if the Supreme Court decides in favor of the president's new immigration program. And so California needs to step up to the plate and ensure that these workers no longer have obstacles and ensure that they enter the workforce. We want to continue along the lines of integrating immigrants into our economy, into our social and cultural fabric, and continue to make our state the great state that it is. And based on those reasons, we ask for your aye vote today.
Thank you very much. Before we go to our next witness, we have a quorum. I'd like to establish it quickly before we lose it. So, Madam Secretary, if you'd please call the roll.
Jackson?
Here.
Jackson here. Morlock? Morlock here. Anderson? Hertzberg? Leno? Here. Leno here. Monning? Here. Monning here. Wachowski? Here. Wachowski here.
And while we're at it, let's go ahead and do the consent calendar. Moved by Senator Leno before I could ask for a vote before he moved it. Thank you for protecting me from myself from last week. So we have a motion to approve the consent calendar, which is items 4 and 6, which are items 4 and 6. Madam Secretary, please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Hertzberg? Leno? Leno, aye. Monning? Monning, aye. Wachowski? Aye. Wachowski, aye.
All right, the vote is 5-0. We will keep the roll open for absent members. My apologies. Please proceed.
Thank you, Madam Chair and members of the committee. My name is Gina De Silva with the California Immigrant Policy Center. We're very proud to co-sponsor this legislation that really addresses the discriminatory and unlawful practice that targets a huge portion of our workforce, which are immigrant workers. Often, due to their status or perceived status, immigrants are the target of this practice by employers that can result in a lost job or workplace confusion. SB 1001 clearly just reflects the well-established and defined federal laws that guide the process for the employers. Despite this clear process, the Department of Justice and trainees in California have cited document abuse as the #1 issue that impacts immigrant workers across the nation. There is clear evidence just through the settled cases alone that this is a commonplace practice in California as well. It not only impacts, impacts all of our immigrant workers, including green card holders and our naturalized citizens as well. SB 1001 would address the prevalence of this practice by building on existing protections to ensure the state remedy protects workers in any context of this discriminatory abuse. We must ensure that employers are following the rules that have been a standard for over 30 years and ensure that our worker populations are not unlawfully prevented from gaining rightful employment to support themselves and their families. As a state with such a large immigrant worker population, our economy can't afford the lost productivity, and our workers can't afford the potential lost wages or jobs. We must ensure that employers are not playing the role of immigration agents as evidenced through this type of discriminatory practice. With the pieces outlined in the bill, California will further protect our immigrant workforce and really uphold responsible business practices. We'd like to thank the Senator for her leadership in authoring this bill, and we urge your support of this legislation.
Thank you very much. Any other witnesses in support? If you'd just step forward with your name, affiliation, and position on the bill. Witnesses in support. Good afternoon.
Good afternoon. Michael Young, California Labor Federation, here in support.
Thank you, sir.
Joseph Villela with Chirla, the Coalition for Humane Immigrant Rights of Los Angeles, in support.
Thank you.
Maya Ingram with the ACLU of California in support.
Thank you. Witnesses in opposition, again, we got no notice of any, so there is none. I have just a quick question. The language you have requested here is the documents that appear genuine on their face. Could you clarify what that means and what examples of what those might be?
Under federal law, employers already have to accept documents that are genuine on their face. Unless they have a reason to believe that it's not genuine, then they can go ahead and ask for additional documents or ask for them to bring back those documents. But it's clearly defined in law, in federal law, and it's been a standard for over 30 years. So we're not asking employers to kind of relearn something new. It's already existing law.
Great, thank you. That was my one question. Any other questions from members? Senator Wieckowski?
On the re-verification, I'm obviously some of it seems like obvious abuse, where I want your driver's license because your driver's license says expired. Clearly, if you drive and that's part of your job, then that seems to be okay. Is the federal law clear on what you can't do on re-verification?
Yes, it's really clear. Like I said, unless there's some overt reason where they need to sort of re-verify or a federal agency might ask them to do so, I mean, it's pretty clear in terms of what an employer is already expected to do. We're not adding anything new.
And are there other tools? I know we have a private right of action in here. Are there other tools? Because I'm trying to figure out, are the people just ignorant, or are they just so mean-spirited?
Or bias.
Or that they employ somebody and then they go about these tactics of, document requests that make it impractical for people to work. And I'm trying to figure out the motivation of folks.
Yeah, well, we've seen instances where they just
But it is.
where they are just targeting the non-citizen workforce at that place of employment. So it's clearly either some type of bias or some type of discriminatory practice.
Okay.
And there's cases that demonstrate that.
And remember, current law provides a protection in instances of retaliation. What we're looking at is the front end when you're applying for a job.
I'll move the bill at the right time.
All right, is there any other? Senator Morlock with a quick question.
Thank you, Madam Chair. Thank you for at least describing what the federal process was, because I knew that the federal government had a remedy, and all I heard was it was cumbersome. But you're saying you have to go to the Office of Special Counsel, and then you have to go to court?
Yeah, then the next level of review is before an administrative law judge, and then the next level of review after that is at the Court of Appeals.
All right.
Then trying to kind of get my arms around the problem. Another problem that's been brought to my attention is that maybe you were not a citizen and you worked for an employer for 19 years, and then you retired, and then they asked for proof of citizenship, and if you didn't provide it, then they wouldn't pay your pension. Has MALDEF been approached about that concern?
I haven't. I mean, we've seen, the most recent case that we've seen was someone who was able to get deferred action for childhood arrival, and the employer just wouldn't accept the work authorization card. And so there's nothing on their website that said that they wouldn't hire anyone who didn't have a green card or who wasn't a non-citizen. The only thing we could tease out from the set of facts was that maybe the employer just didn't agree with the president's creation of these new administrative forms of relief. I mean, it's not too hard of a stretch to believe that under the current political environment with regards to immigration, that there may be employers that are just flat out opposed to the president's new programs and may find this as a way to sort of make a statement or discriminate against prospective employees. I mean,
So
there's-
I'm going to,
I haven't heard of this problem that much either. Are there some news clippings that I could look up?
We have some case samples that I think we left with the consultant, but we could definitely bring some by and let you look at those.
Thank you, Madam
great. All right, we have a motion. Do you wish to close, Senator?
I ask for your aye vote.
Thank you. All right, motion to pass to Senate rules. Madam Secretary, please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Anderson? Hertzberg? Leno? Leno, aye. Monning? Monning, aye. Wachowski?
Aye.
Wachowski, aye.
That has 4 votes. We'll hold the roll open for other members, the absent members, and I am going to pass the gavel on to Senator Morlock because I have to go present myself, or not present myself, but present a bill myself. And why don't we have Senator Leno take up item number 3, SB 1163.
Might be more than, if that was the case, I would have tried to help this morning.
Yeah, my whole morning was booked. Welcome, Senator Leno.
Thank you, Mr. Chair. Good to have you back. So thank you for the opportunity to present SB 1163, which deals with due process for firefighters. Of course, we're all well aware that firefighters and emergency medical personnel put their lives on the line every day to keep all of us safe. Firefighters deserve the same due process as other emergency medical personnel. The legislature and governor deemed it appropriate to extend a level of due process for firefighters when disciplinary situations arise via the enactment of the Firefighters' Bill of Rights, which was in 2007. It included a limiting clause which applies its due process protections only in those events and circumstances related to a firefighter's official duties. The Firefighter Bill of Rights is designed to apply principles of fairness and professionalism to the process of investigating and disciplining firefighters. In some cases, a firefighter's official duties may also include providing emergency response services, which requires that the firefighter maintain a paramedic license or certification as an EMT. The paramedic licenses and EMT certifications are subject to the state's Emergency Medical Services Act. Under the EMS Act, disciplinary cause may include investigations and discipline that may result from conduct away from the job or not strictly related to the performance of a firefighter's official duties. And this is getting to the heart of the bill here. So the bill will conform the Firefighters' Bill of Rights to the state's Emergency Medical Services Act to ensure that procedural protections apply when a firefighter may be subject to punitive action that will impact their ability to perform their job-related duties. The protections in the Firefighter Bill of Rights are simply procedural due process rights. This bill only relates to due process for licensure. It will not change anything in a criminal investigation, and that's actually worth repeating because from reading the oppositional letter, there seems to be some confusion on this point in particular. This bill only relates to due process for licensure, and it will not change anything in a criminal investigation. I have Christy Boma with the California Professional Firefighters here to say a few words and answer any questions you might have. Thank you.
Mr. Chairman, members, Christy Bauma on behalf of the California Professional Firefighters. Pleased to be sponsor of this measure. Senator Leno has covered it very thoroughly. I will just add that the Firefighter Bill of Rights itself has exclusive tolling provisions if we find ourselves in a terrible circumstance where a firefighter has conducted himself in a criminal manner, that all limitations on a certifying agency's ability to discipline, or an employer for that matter, are tolled. And they can, subsequent to the final determination of that criminal proceeding, still, should that member still be employed, exercise their right to impose job-based or licensure or certification-based discipline. I would also add that in 90% of the cases, Firefighter Bill of Rights applies to both these entities, the licensing entity and the employer. This is just this small window that the Senator mentioned in his opening remarks. And we view this as an important measure, not just for the public, so that investigations are conducted appropriately and the appropriate discipline is imposed, but also for fellow firefighters who may find themselves on the job with folks that are challenged by these misconduct allegations, so that we have a service that the public can rely upon. So we urge your support today.
Thank you, Ms. Belmont. Are there any other witnesses in support?
Michael Young, California Labor Federation. Sorry for the delay in getting our letter in, but we're also here in support. Thank you.
Good afternoon. Afrak Vargas with the California State Firefighters Association, representing 17,000 career and volunteer firefighters.
All right. Any witnesses in opposition?
For the California Association of Joint Powers Authorities. We are in that tweener position. We are trying to find clarity on this bill for our agencies which do the risk pooling and risk management for local public entities. We think that there is a need for more clarity in the bill to ensure that this really very specifically states this is only for on-duty issues that arise that affect the licensure and certification of that firefighter paramedic. We would love to work with, we are actually working with the author and his staff trying to resolve this, but at this point we are opposed to the bill.
Thank you, Ms. Burra. Anyone else that is in opposition?
Of course, thank you.
Do I have any questions from the members? I have a motion. Senator Leno, do you wish to close?
I respectfully ask for your I vote.
There is a motion, so why don't we just go ahead and call the roll, and Madam Clerk, you can announce it.
The motion is due pass to Senate Appropriations. Jackson, Morlock, Anderson, Hertzberg, Leno.
Aye.
Leno, aye. Monning. Monning, aye. Wachowski. Wachowski, aye.
So it's 3-0, and we'll hold it open.
Thank you very much.
Thank you, Senator Leno. That takes us to
Senator Morrell.
Well, Senator Wachowski just bailed, but that was consent. So we are waiting for, well. Oh, okay. Oh, I'm sorry, that was not on consent. Yes, please. Thank you, Senator Monning. I stand corrected. I apologize. Okay. All right, Senator Morrell for Senate Bill, excuse me, Senator Monning for Senate Bill 1023.
Thank you, Mr. Chair, and I'm sitting in for our chair, Senator Jackson, but this bill is presented on behalf of the Judiciary Committee. I'd like to present our committee's bill, Senate Bill 1023. This bill would fund 12 new judgeships and their accompanying staff. These 12 judgeships would be created in the counties most in need of judges as determined by the Judicial Council's Judicial Needs Assessment. 4 of these judgeships would be allocated to San Bernardino County, 3 to Riverside County, and 1 each to the counties of Fresno, Kern, Los Angeles, San Joaquin, and Stanislaus. I thank all of my colleagues on this committee for your continued support of the judiciary and your recognition of the importance of access to justice. The judicial branch was severely hit with budget cuts. While we are beginning to reinvest in the branch, we are not sufficiently reinvesting. When the judicial branch is not fully funded, all Californians suffer. The ramifications of the judgeship shortage are serious. They include a significant decrease in access to the courts, compromised public safety, an unstable business climate, and backlogs that inhibit justice. Justice delayed is justice denied. And colleagues, all of these bills we pass have no meaning if there's no way to enforce the laws we create. An analysis of judicial workload conducted in 2014 identified a need for more than 250 additional judges to satisfy workload requirements in our superior courts. The bill before you is very modest and only gets 12 judgeships to the counties most in need. Members, I have witnesses to testify in support of our committee bill today. The Honorable Jonathan B. Conklin is the chair of the Judicial Council's Trial Court Budget Advisory Committee and Superior Court Judge in Fresno. And the Honorable Harold W. Hopp is the presiding judge of the Superior Court in the County of Riverside. Members, I ask for your aye vote, and Mr. Chair, with your permission, would like to present the witnesses in support.
Please, but Senator Monning, we've all co-authored this bill, is that correct?
That's correct.
And because we're discussing it, there must be something wrong with it, correct?
I hope not.
Oh, okay.
We believe in the principle of total public transparency.
Thank you for reminding me. Thank you, Senator Monning. Judge.
Good afternoon. I'm Harold Hopp, the presiding judge in Riverside County. As you probably are aware, our county is one of those most impacted by the shortage of judges. This is something that has developed over the years as our county has grown significantly, now 2.4 million residents. But the number of judges has not nearly kept pace with the increase in population growth and caseload. And so I'd encourage you to support this. It will be a small but important step in getting access to justice for those 2.4 million Californians that live in our county. We're doing the best we can. I joke with some of my colleagues from other places in the state that one good thing about having a shortage of judges in Riverside County is life is never boring, because there's always lots of work to do. So I encourage you to support this. Thank you.
And I'm John Conklin, the presiding judge of the Fresno County Superior Court just passed. I joined Judge Hoff in his support of the bill as well. Ask your support. Like his court, our court is challenged by the lack of judges. We are currently authorized for 60, we have a need of 60, authorized for 49, so we're 11 short, which leads, frankly, to a denial of access to justice in our court as in others. We have the same long lines. We have judges typically with caseloads exceeding 100 a day, and when you have 100 cases in one courtroom a day, I'm sure you can not even imagine but perceive the shortage that creates, the lines that creates, and the lack of time it creates to dedicate to each case so that the litigant feels they have their day in court. We're doing our best, but with the numbers we have, until those numbers are increased, we can't reach that goal, and we thank you for your support.
Thank you, Judge. Are there any other witnesses in support?
Corey Jasperson on behalf of the Judicial Council, in strong support, and happy to answer any questions if you have any.
Brian McCabe, presiding judge of the Merced Superior Court, also the chair of the state's trial court presiding judges advisory committee, and on behalf of that group, in support.
Mr. Chair and members, Lexi Howard with the California Judges Association, in strong support.
Thank you all for coming today. I appreciate your coming and giving testimony. It shows that you do have extra time. I don't know what you're complaining about. Are there any witnesses in opposition? Are there any witnesses in opposition? Senator Monning, the floor is yours.
Thank you.
Unless I have questions from my colleague. Senator Leno.
Not so much a question as a comment before we vote. I do my very best to remain neutral on bills that have appropriations in them as my responsibility as budget chair. I voted for a very similar bill authored by Senator Roth last year, so I also want to be consistent in my vote. So I just want to say that don't get any ideas if you're appropriating in your bills. I likely won't be supporting them, but this one was exceptional for me last year when Senator Roth authored it. It is exceptional for me today as well. This will be very much a part of our budget committee negotiations with the administration, and so I will be advocating, of course, for funding of judges. It would be disingenuous for me not to cast a vote for it today. The concern of access to justice is a real one, and we hear too many stories of, especially in rural areas and more interior counties in the state, where people are literally driving 3, 4, 5 hours to get to a courtroom because entire courthouses have been closed down, as Judge, you know all too well. And then, of course, to arrive at 3 o'clock and be told, come back the next day. Well, working people can't afford to do that, and it's not fair to do them, to them. So with that caveat, I will be voting yes today, but also carrying the banner as we go into the budget negotiations.
Thank you, Senator Leno. Senator Monning.
Thank you, Mr. Chair. I want to thank Budget Chair Leno for those comments. I, too, usually refrain from bills that have allocations, but for the same reasons you articulated in maintaining consistency as a member in good standing of the State Bar. My only reluctance in moving this forward and asking for your aye vote is I don't see allocations for San Luis Obispo, Monterey, Santa Cruz, or Santa Clara counties. That said, in the spirit of building our justice system statewide, I would close by urging an aye vote for the reasons previously advanced. Thank you.
Thank you, Senator Monning. I believe Senator Leno is going to move the bill. I believe that the lashing should continue until morale improves. Why don't you call the roll, Madam Secretary?
The motion is due pass to Senate Appropriations. Jackson? Morlock?
Yes, aye.
Morlock, aye. Anderson? Hertzberg? Leno? Leno, aye. Monning?
Aye.
Monning, aye. Wachowski?
All right, we'll keep that open.
Thank you.
Thank you. 3 votes in support. And that takes us now to Senator Morell with Senate Bill 1431. Senator Morell, you have the floor.